Welcome, everyone. Thank you, everyone, for joining us. This is our fifth and final session in our talks and recent developments in DIFC law. Today, we're going to be looking at procedural law and appeals. I should say before we start that the session is being recorded. We are joined by Tom Smith, QC, who needs no introduction. As many of you will know, Tom and I have recently published the DIFC Courts Practice, a new book on DIFC law and practice, Part A focusing on recent developments in DIFC law, Part B being an annotation of the rules of the DIFC Court. I think both of us have had it quoted or cited against us now. Neither of us has sought to blame the other for the relevant sections which have been cited against us. And I would like to take this opportunity to thank all of the contributors who have done such splendid work in their sections. This series of webinars has pretty much tracked the relevant chapters in Part A of the book, and we hope that it will give you some sense of the value of the book to practice in the DIFC and around the DIFC and generally in arbitration and litigation in the Middle East. We hope too that the publication of a serious heavyweight textbook on DIFC law reflects the emergence of DIFC law as a mature body of law and indeed as a distinct area of legal expertise, which we now have. Our speakers today are Sophia Hurst, who will be speaking as the junior of Dan McCourt Fritz. Remarkably, only 6 years cool, she has extensive offshore experience, particularly in the BVI and Dubai. She's developing a formidable reputation in areas of practice as diverse as banking and trusts. She's acted in a number of leading DIFC cases, recently successful in Grand Valley and Jitco in the DIFC Court of Appeal, which is part of the wider Suntec litigation. Harris will be well known to many of you. He has an extensive, substantial Middle East practice, both in arbitration and litigation. He's been involved in some landmark DIFC cases, DNB and Gulf Ayada, Sky News, Kasab Media, MAG and Theron, to name a few. On the arbitration side, he was recognized or shortlisted last year as Legal 500 Arbitration Junior of the Year. Sophia will be talking about procedural issues. Harris will be talking about matters relating to appeals. Tom and I will be adding our pennyworth at various stages along the way, but without further ado, I shall hand over to Sophia on procedural.
Thank you very much, Rupert. Within procedural law, I'm going to focus today on interim remedies. And of the arsenal of interim remedies available under RDC 25, the most potent form is the freezing order. And I think recent developments in the DIFC case law here demonstrate the jurisdiction adapting that remedy flexibly to meet the particular needs of the jurisdiction. And I think we see that in particular in freezing orders granted in support of enforcement of judgments and arbitral awards. So by way of very brief reminder of the basics, the classic requirements for obtaining a freezing order: one, that the applicant has a good arguable case on the merits; secondly, that the defendant has or may have assets which will be available to satisfy the judgment against him if judgment is given in the claimant's favour; thirdly, that there is a real risk that the judgment will not be satisfied by reason of an unjustifiable disposal of those assets; fourthly, that in all the circumstances it's just and convenient or appropriate, to use the language of the RDC, to make the order sought. I'm going to take them slightly out of order and look at the third of those requirements first. And in my experience, often the key battleground on an application for a freezing order is establishing risk of dissipation. What's interesting here, I think, is that the recent decisions arguably show the DIFC court being more flexible on this area, in contrast with recent retrenchment in the English commercial court. But in both jurisdictions, there are two potential limbs to establishing risk of dissipation. In what has become quite a key passage of Mr. Justice Flo, as he then was in the Congentra case in the English Commercial Court. He explained that a risk of dissipation can be satisfied, limb 1, where unless restrained by the injunction, the defendant will dissipate or dispose of his assets other than in the ordinary course of business, or limb 2, as I'm going to call it, that unless the defendant is restrained by injunction, assets are likely to be dealt with in such a way as to make enforcement of any award or judgment more difficult, unless those dealings can be justified for normal and proper business purposes. And on that limb 2, Mr. Justice Flo found that real risk could be established where the claimant had shown that the respondent had engaged in what at its lowest is discreditable conduct, and that they had shown that they were the sort of people who will stop at nothing to frustrate the claimant from making any substantial recovery. That case is in 2008, and in my view, recent cases in DIFC are breathing new life into that limb 2 in particular. So it was taken up enthusiastically by Mr. Justice Chadwick in the Bossamar International and Emirates trading case in 2016. And there he approved Mr. Justice Flo's conclusion that showing an unacceptably low level of commercial morality could be sufficient to establish a risk of dissipation. He described it as the has shown form factor, i.e. that the person against whom the injunction is sought has shown by their past conduct that they are likely to stop at nothing to frustrate the enforcement of, in that case, the arbitration award. And that this can be shown by taking hopeless points to challenge an arbitration award or a judgment, running arguments that are subsequently abandoned, and in all the circumstances, those sorts of devices lacked commercial morality, lacked good faith, and were enough for the court to conclude that a freezing order was appropriate. Now, I think that sort of flexibility is very welcome from an applicant's perspective, and in particular where we're dealing with enforcement of awards and judgments. But if you're acting for the respondent in opposing one of these freezers, it may be useful to contrast some of the more recent English cases, which appear to be focusing solely on limb 1 rather than limb 2, and have perhaps become more cautious. So, for example, in Fundo Sobrano and Dos Santos, a 2018 decision of Mr. Justice Popplewell, he emphasised there that general allegations of bad behaviour will not normally suffice, and that the matters alleged must specifically evidence a risk of unjustified dissipation of assets. Now, that's a very limb 1 approach, and he seems not to have in mind the more flexible limb 2 approach embodied in Mr. Justice Chadwick's judgment. Secondly, it's common to refer to allegations of dishonesty in the substantive claim as a way of justifying freezing relief and in particular establishing risk of dissipation. But that alone will not be sufficient. Applicants cannot pull themselves up by their own bootstraps in that way. There has to be a specific link to the dissipation. And in a very recent decision of the 28th of May of this year, the argument was considered as to whether inferences as to risk of dissipation could be inferred from evidence of a lack of commercial probity, but falling short of outright dishonesty. And Mr. Justice Freeman said, just as dishonesty does not necessarily prove real risk, how much more so where the case is lacking some commercial probity, falling short of dishonesty. And there again, I think the court appears to be forgetting that limb 2 is potentially up their sleeve. And that contrasts with Mr. Justice Flo's discreditable conduct or Mr. Justice Chadwick's lacking in commercial reality, both of which were sufficient to evidence risk of dissipation. But I think it's important to bear in mind the particular context in which the DIFC has adapted these rules, and that many applications for worldwide freezing orders in DIFC are brought specifically in aid of enforcement of judgments and awards obtained elsewhere. So in that context, the underlying claim may not have been one making specific allegations of fraud or dishonesty, and so other conduct of the respondent comes into play. And that that's the context for statements such as those by Mr. Justice Chadwick and Bossamore, saying that past conduct can be a basis to conclude the likely frustration of the enforcement of the award in the future, not that they necessarily have engaged in specific dissipation activity. Finally, I think it's interesting to note the reference by the Court of First Instance in the Ahmedova case to the so-called flexibility principle, which is that where a defendant seeks to use what the court described as offshore trusts and company structures to render themselves judgment-proof or resist enforcement, the court should exercise its jurisdiction in a flexible and adaptable manner to thwart that kind of action. And in that decision, the judge relied on key English decisions in the Aboyazov and the Pugachev litigation as founding that flexibility principle. It seems to me that that includes developing the approach to risk of dissipation along the lines that Mr. Justice Chadwick did in Bossamore, but also that it seems to be reflected in decisions on the second condition for granting relief, that the defendant has or may have assets available to satisfy the judgment. Now, historically, the position has been that those assets have to be shown to be within the jurisdiction of the court. That requirement has substantially relaxed over time in the courts of England and Wales, and similarly now in DIFC. So insisting on showing assets within the DIFC, I think, would have seriously curtailed the circumstances in which a freezing order could be granted. And so it's unsurprising that recently, in a series of extempore judgments, the court has confirmed there is no need to show assets in the jurisdiction of DISC in order to exercise the freezing order jurisdiction. And with that, I'll hand back to Rupert and Tom.
Thanks, Sophia. That's really interesting. I mean, it's certainly my experience that risk dissipation has become the major battleground in many freezing applications. It seems to me that the high watermark recently was the decision both of Mr. Justice Fields and of the Court of Appeal in the IMF and BankMed litigation. That was a freezer being sought for up to a value of $750 million US dollars. I mean, at first instance before Field, the focus was on the first limb of congentra. So there was a suggestion that because the bank was trying to charge a negative interest rate, this indicated that monies had been transferred out of the jurisdiction into Europe, where that sort of practice was common. And and Justice Field pointed out that obviously in a banking relationship, it's a contractual relationship. So what the bank does with monies paid into it is a matter for the bank. Emphasizing, I should say, the extraordinary difficulty ordinarily in getting a freezing injunction against a bank. It then went to the Court of Appeal, and the focus was much more on the second limb. So one had a Lebanese bank that was refusing to repay a pledge in respect of it, which was securing a facility that it had terminated. And there was various discreditable conduct in respect of failure or delay in providing finance and false and misleading excuses that were given for not providing the finance. But that was not found to be enough by way of discreditable conduct. So that case, in a way, sets the benchmark. My experience in more recent cases is that the court is generally willing to find risk of dissipation, particularly in arbitration cases, as you suggested with Bossamore, where you've got an award debtor who has essentially disengaged from the arbitration process, and in a recent case where they gave false evidence to a foreign court in enforcement proceedings, and where they use opaque corporate structures. So where one has those sort of circumstances, then the court is willing to find a risk of dissipation. And I should say, too, there are cases emerging out of various scandals, financial scandals, involving certain groups of companies at the moment. And in one of them, which I was involved, CEBD and Shetty, where there was evidence emerging of off-balance sheet debt, of related party transactions, and indeed potentially of fraud. That was found enough too by Justice Wayne Martin. So the general trend seems to be that the court is relatively willing in this age of highly technological fraud to be willing to find risk of dissipation. But there are cases, and there is that decision, the Court of Appeal in BankMed, where a line was drawn. Tom, I know you do a lot of work in relation to freezing injunctions. I'd like to just go, if I may, to the first of the requirements in ITMAR, the requirement that there be a good arguable case I think it's both on jurisdiction and on merit. So can you unpack that a bit for us to explain what that means in practice?
Well, that's an area where the DIFC court's practice is having to kind of play catch up to the developments that there have been in the English law on this, because I think we've previously understood in England good arguable case to mean you've got the better of the argument, or you've got much the better of the argument, and there was, as has recently been said in the Court of Appeal in England, gloss upon gloss and explication upon explication as to whether or not what's the difference between better and much better. But ultimately, the test was presented as a kind of weighing between the case of the claimants and the case of the defendants. And now, since the Kefa case in the jurisdiction context and the more recent case, L'Academia, which applies that into the freezing order context, there's a more nuanced approach. And so the question arises, when you've got a factual dispute, which really goes to the heart of this, how does the court deal with that at the interlocutory stage? And I mean, I think that it's now fundamentally different from just weighing in the balance the two different cases. What you have to have is a plausible evidential basis for your factual case. And that then unlocks the potential to show that there's a risk of dissipation and so on. And that can make a real fundamental difference. So I was just arguing a case recently where what was being said was the document was forged. And so it was possible to show that both parties had a plausible evidential basis for the allegations that they were making. And so the question was, is that sufficient? Or did you, as the other party was saying, did the court have to take a view about who had the better of the argument at that stage? And we don't have judgment on that yet, and we may not have it for a while now, but that's going forward. Just on the issue of risk of dissipation, though, I mean, I think it's interesting, and I agree with you, Rupert, that the DIFC court is starting to take a more critical approach to this. This can be sometimes left as a bit of an afterthought once people have established their claim, particularly if there's a bit of a whiff of fraud going on or some sort of discreditable conduct. I mean, I think this is a prime example of a situation where applying a rigid taxonomy is not necessarily going to be that helpful, because ultimately what the court has to do is look at the evidence in the round and see whether it can infer from one set of conduct that there's going to be, or there is a risk of another kind of conduct, the other kind of conduct being dissipation. And so, I mean, I think there's definitely room for a disparity of judicial approaches to that, but sort of trying to apply rigid, strict rules, as frankly, I think one can detect in the judgment of Friedman from England. I'm not sure that is quite the context. One can, of course, see that just because you misbehaved in one category of cases, you're not necessarily going to misbehave in another. But in many cases, you can draw that inference. And so take Bossamar, for example, where a party is actually has had the argument, has submitted themselves to the jurisdiction and had the argument about whether or not they owe this money, and they're still taking technical points and sort of somewhat devious technical points to try to evade that. Then why is that not indicative that they might make other steps which they see as being legitimate, but which are in fact not?
Yeah, thanks, Tom. Sophia, I think you're going to tell us something about notification orders at this stage.
Yes, so I think that perhaps a lesser known remedy, and often unfairly thought of as the freezing order's poor relation, I do think there are interesting uses to which the notification order can be put. I should explain, by way of notification order, I mean an order that requires a respondent to give notice of any dealings with or disposal of assets that fall within the scope of the order as crafted, rather than jumping straight to freezing them. So, for example, give 48 hours notice of any transaction above a certain value. It's worth mentioning that isn't an order specifically included in the menu of interim remedies in RDC 25.1, but it is effectively classified as a modified version of a freezing order. And I am aware that of recent ex parte decisions granting that kind of relief in DIFC. And two ways of using them. So one is the bolt-on option. English authority has recognised the jurisdiction to add notification requirements to a freezing order, effectively as a means of fortifying the injunction where that's necessary to ensure that the value of the assets isn't diluted and dissipated. And there's a risk that the freezing order itself wouldn't be sufficient. so most commonly used in circumstances where the respondent is asked to give notification of dealing with assets of non-defendant, non-respondent companies or related entities and individuals. And that jurisdiction was recognised by the Court of Appeal in Lakatamia Shipping. Now, that has obvious attractions where you're dealing with a group structure or an individual perhaps exercising control behind a series of corporate respondents. It also potentially flags up a potential way around the issue that arose in Akhmedova in the Court of Appeal. So in that case, the applicant wife had applied for a freezing order in support of an English judgment in financial remedy proceedings against the defendant ex-husband. She applied for the freezing order not only against Mr. Akhmedov, but also an entity to which he had assigned his interest in a rather nice super yacht. And the Court of Appeal decided that the freezing order could not extend to the entity holding the yacht because it wasn't party to the underlying proceedings in aid of which the freezing order had been granted in support. Now, in Akhmedova itself, the issue was resolved because that company was joined to the foreign proceedings and the judgment in between the first instance of the Court of Appeal decision here. If that's not an option, it strikes me that you could try and use the necessary and proper party jurisdiction recently recognised by the Court of Appeal in Nest Investments and join in parties to the DIFC enforcement proceedings. But it seems to me far simpler to bolt on a notification order of the Lakatamia kind, where you already have jurisdiction over the primary respondent, and they are then responsible for telling you about any dissipations of assets by related entities. It is a more straightforward freestanding notification order, such as was elaborated by the Court of Appeal in Holyoke and Candy in the English courts. They clarified in that decision that where a notification order is drawn in wide terms, it is effectively a modified version of a conventional freezing order. And so the same test in relation to dissipation of assets that we've just been talking about applies. But they did leave a curious nugget that if the order is not a wide notification order, but it's a simpler order, simply requiring notice to be given of a particular transaction or a particular threatened dissipation, risk of dissipation may not apply as a test, although quite what the test would be was left very open. Now, in both of those cases, freezing orders and notification orders, we're in the vast majority of cases talking about going ex parte. So once you've got the order, Rule 2393 provides that you must then serve it together with the application and the evidence in support. Again, that service has to be on any party or any person against whom the order was made or sought. Now, it's generally accepted that serve means serve, and strict compliance is going to be necessary at some stage, not least in order to preserve the jurisdiction to bring contempt proceedings. But equally settled, I think, is the idea that once a respondent becomes aware of or has been notified of a freezing or notification order, even if that's falling short of strict service, they are then bound and must comply with the terms of the freezing order. So there is some tension between formal service of the order and compliance with the rules on the one hand versus the need to bring proceedings swiftly to the attention of respondents in order to ensure the order's effectiveness. I say strict service and formal service, but actually as a matter of DIFC law, I think it's worth emphasising the fact that the strict rules can in fact be very flexible. So RDC 9.1 gives the court a general power to order otherwise than as provided in Part 9, even outside of the circumstances where it can order substituted service or service by an alternative method, or dispense with service altogether. We see increasingly anecdotal evidence of orders for service via WhatsApp or social media platforms being sought and obtained in common law courts around the world, where speedy notification of the terms of an order is absolutely essential. I'm not aware of any DIFC court decision granting service via WhatsApp, but there's no reason to suspect that the rules could not accommodate that. How flexible the court can be where the parties are located outside of the DIFC is perhaps open to doubt. And I'm thinking here about the Court of Appeal decision in Pearl Petroleum. So there it was recognised that the flexible rules permitting substituted service or dispensing with service can be deployed even where service is being effected outside of the DIFC or Dubai, but they cannot be used to get around provisions of international conventions such as, in that case, the Riyadh Convention or the GCC Convention. And Justice Jeremy Cook held that the Riyadh Convention has the force of law, is deemed to be part of domestic UAE and DIFC law, and as a result, the mandatory Article 6 of the Riyadh Convention, which is very cumbersome consular state-to-state service, is mandatory in its terms and can't be circumvented by an application for substituted service. Now that, to me, seems to stand in slightly strange contrast with the direction of travel, particularly in the onshore courts where this civil procedurals have recently been amended to make electronic service much easier. So in 2018, there was a cabinet resolution providing by Article 6 that service was permitted by recorded voice or video calls, messages on mobile phone or smart applications, email, fax, or any mutually agreed means. Now, in a more recent cabinet resolution in May 2020, that's slightly thrown into doubt because Article 3 of that resolution permits the court to authorise litigants to serve except by modern means of communications. And it remains to be seen how that's going to be interpreted and applied in the UAE courts.
Thanks, Sophia. Notification orders, very, again, an interesting area. I think I got one last week. Well, I did get one last week. I thought it was a first, but I understand that Tim Killen may have obtained one sometime earlier. Lacatame is a very hard judgment. I mean, for the benefit of our audience, in my experience, the FAM decision is FM Capital Partners decision is much a clearer judgment by a deputy judge, which sets out the principles and gives an example of the terms of a draft order. So that's worth looking at if you're considering getting a less draconian order, a notification order. Tom, I think on the service issue, you may have a sort of breaking news, if I can call it that.
Yes. So can I just check that you can hear me, because I had to change microphones. Thanks. So it's obviously since Pearl Petroleum back in August 2017, wherever you've got a party who's in a Riyadh Convention state, the position appeared to be, according to the judgment in that case, that you had to go through the court-to-court service mechanism that's prescribed in the Riyadh Convention or the equivalent provisions in the GCC Convention. And in Pearl, that was a particular problem because service was being blocked, or it was anticipated that service would be blocked. I've literally just this morning had a judgment in where we were seeking to challenge the effect of Pearl. We sought to distinguish it and to challenge it. And I've just got judgments today in which the judge has found that it could be distinguished and it was wrong. So it's very interesting. Now we've got these two conflicting decisions. It's an in-arbitration case, so I can't circulate it yet. But I'd be very surprised if it didn't ultimately end up being reported. I suspect that there may be round two to come, but I'm hopeful that will be accepted to be the right decision, because the practical effects of court-to-court service have really been problematic. Even where it works absolutely as it should do, it takes months. And if the answer is that you have to serve before anything can become effective, then it really does bring into question the value of freezing orders, interlocutory relief, and actually the practicality of conducting proceedings at all against a party that's based in one of those states. What needs to be served? Everything, because legal and non-legal documents need to be served. Every single pleading, every single witness statement, in theory. And the effect would be, in my view, pretty negative. And it has caused problems so far. So I'm hopeful that will be the way that the court decides to go ultimately, but we shall see.
Thanks, Tom. Right, now we have Harris on the subject of appeals.
Thank you, Rupert. Can you hear me okay?
Yeah.
Good. Well, it's great to be back for this final installment of the series, and I just can't wait to find out who wins the quiz, which I'm not sure we've actually mentioned, but I'm very excited about that. As you say, I'm going to speak about appeals, and particularly want to talk about appeals on issues of fact and decisions involving discretion and evaluation. The obvious point about these areas is that there is never or rarely one correct answer. We're dealing here with perspective, not mathematics. And this, of course, is very different to decisions on pure points of law, which will invariably have a right or wrong answer. But before I launch in, we should remind ourselves of what we need to win an appeal. Firstly, in almost all cases, we will need to obtain permission to appeal from either the Court of First Instance or the Court of Appeal. In order to obtain such permission, we'll need to show that there is either a real prospect of success on appeal or that there is some other compelling reason why the appeal should be heard. This is the same test as that applied in England, and the courts confirm that a realistic prospect of success simply means not fanciful, which is code for not absolute rubbish, basically. Once we have our permission, we then need to show that the decision of the lower court was either wrong or unjust because of a serious procedural or other irregularity in the proceedings. And a decision will be wrong where there are errors of facts or errors of law. And as I say, I want to focus on cases where facts are an issue and other areas where there is no clear right or wrong answer. The key DIFC case dealing with appeals on points of fact is Al-Kharafi versus Saracen Alpen of 2015, a case involving margin calls under various structured financial products. In rejecting the appeal in that case, the Court of Appeal emphasized the heavy burden on an appellant seeking to challenge a finding of fact. The case further reminds us that the trial judge, unlike the appeal court, sees and hears the witnesses and is better placed to assess their credibility. The Court of Appeal also confirmed that the test on an appeal against findings of fact is whether the challenged finding is plainly wrong. Provided, therefore, that the judge's finding, and I'm quoting, falls within the range of proper judicial conclusions, then there cannot be an appeal. Al-Kharafi was also useful in clarifying that an appeal is not going to be made stronger just because the judge delays in producing the judgment, even if this is by many months. In Al-Kharafi itself, the judgment followed just over a year after the hearing. And the court didn't think that this was serious irregularity and suggested that an appeal court considering delay will need to have regard to the scale of the case, the volume of the documents, and the number of factual and expert witnesses. The real issue in each case is whether the trial judge has retained a full grasp of the issues and evidence when writing the judgment. The Court of Appeal in Al-Kharafi also declined to find that occasionally impatient interventions of the trial judge constituted a serious procedural irregularity or were unfair. And this, I think you'll agree, is very reassuring, as I'm sure none of us would want a judgment which might discourage impatient interventions by trial judges. You might think that given the difficulties of appealing points of fact, there would be very few cases where such appeals have succeeded. And in fact, you'd actually be right. However, in VTG versus Muhammad, which is 2018, the appeal court allowed an appeal against a decision that a memorandum of understanding in relation to a transfer of property had been fabricated. The appeal court found that the judge's conclusion was against the weight of the evidence and was one which, and again I'm quoting, no court properly directing itself could have reached. The decision was therefore wrong in law. And this was also a case where fraud hadn't even been pleaded, yet the judge's finding implied wrongdoing of this sort. The Court of Appeal took a dim view of this and rolling out that snappy phrase that fraud must be distinctly alleged and distinctly proved. And the point basically is that a court cannot reach a decision on fraud without allegations having been made and proof. Mag versus Theron, 2017, is another case where an appeal on points of fact succeeded. And this was one of mine. In that case, we managed to persuade the DIFC Court of Appeal to reject the claimant's factual evidence of future damages. This evidence was presented as a table prepared by a consultant who didn't appear as a witness, purporting to show past profit for a similar project to the subject of the dispute in a different location. The Court of First Instance had awarded damages based on the table, but the Court of Appeal observed that there was no verification for the figures before the lower court, and the consultant who actually prepared the table had not appeared to give evidence. In the end, the respondent sought a much lower damages amount on its alternative wasted costs case, which had made in the court below, and which the appeal court allowed. And this raises the issue as to when the appeal court would allow new submissions on facts, which submissions that hadn't been made in the lower court at the appeal stage. My sense from the 2015 Damac Towers case is that the appeal court may well allow new points to be argued in the appeal, but not where the evidence in the lower court would have been different. So much for appeals on fact. What about decisions involving the exercise of discretion or other evaluative decisions, which can involve issues of mixed fact and law? The basic point here is that the Court of Appeal will grant the Court of First Instance a wide margin of error. Applying the English court approach, the DIFC Court of Appeal will only interfere with a decision on the exercise of discretion where the judge erred in principle or took into account irrelevant factors or failed to take account of relevant factors and or came to a decision which is plainly wrong or falls outside the generous ambit that we've just mentioned. And these principles have been confirmed in Fidel versus Felicia 2015. And so in Veggie Bar, the Court of Appeal dismissed an appeal against an order for security for costs, and the appeal court stressed that the matter involved discretion and that it was engaged only in a review of the first instance court and not a rehearing, and the decision fell within the margin of error. The same principles set out in Fidel versus Felicia apply to evaluative decisions, for example, decisions not to stay proceedings on forum non-convenience grounds, or decisions relating to whether there's been an abuse of process. Again, an appeal against such decisions are likely to be hard, but not impossible. See, for example, Al-Kharafi versus Bank Saracen in 2018, where a decision on an abuse of process was overturned. That's it from me. Over to you, Tom and Rupert.
Thanks very much, Harris. That's very interesting. Tom, there's a general perception that the DIFC court is relatively generous in giving permission to appeal. How do you set about seeking to interest the court when you're at the stage of seeking permission?
Well, I think you're probably right. I think that in terms of giving permission, it's slightly waxed and waned. So at the beginning of its life, they used to give permission to appeal in a broad range of cases, and it was pretty rare that permission was refused. Then they turned a corner, I think, a little bit, and things changed a little. And you started to see appeals being rejected at the permission stage quite early on. And more recently, my sense is that it's a bit more permissive again. I mean, I think if you're applying for permission to appeal, I think firstly, if there's anything of importance or there are conflicting decisions, then that is obviously something which is important to bring to the court's attention. But I think that the key thing that I would advise is be upfront. So what I mean by that is, if you are trying to appeal against one of the sorts of decision that Harris has mentioned, a decision of fact, a decision of discretion, an evaluative decision, you have to explain that, show and be upfront about meeting that test. So what is it that you say was wrong about the approach to it, not just trying to take pot shots at the decision and then dress it up as effectively a decision of law or some other matter. You have to identify the point of principle if you can. And similarly, I think, and this is where I've seen people go wrong, if you have new points that you wish to raise that clearly were not raised below, don't just ignore that. I think you have to be upfront about it. You have to seek permission for it. And you have to address the question that Harris mentioned, which is, would the evidence or could the evidence have been different if you'd raised this point below? And my personal experience of that is that the court has tended to apply a fairly limited threshold to that question. If you're dealing with the construction of a contract, despite the potential relevance of subjective elements in DIFC law, I think that the DIFC Court of Appeal is likely to entertain new points on construction, new points on pure law. But in my experience, if there is the possibility of facts being differently presented, then you're not likely to get permission. And so in your application, you'll just need to explain and justify why, in this case, you can get permission. I mean, the court will always interrogate at the appeal stage why it is, if they get permission, why it is you say that this is a point that can't be raised. What new facts, what evidence is it that you say would have been relevant? But if the respondent can answer that question, even if it's a somewhat speculative, somewhat slightly vague answer, depending on the nature of the question at issue, it may well end up being a problem for you as an appellant. So I think you've got to get out ahead of that. You have to take ownership of it, and you've got to try and deal with it.
I mean, DFC law is developing so fast, isn't it? And there are so many issues that often arise from conflicting or diverse first instance decisions, particularly where they arise in arbitration or on interim applications where the reasons may be relatively brief. And it's pretty useful to be able to present the Court of Appeal with an opportunity to lay out the relevant principles as the law evolves. And you were talking earlier about construction. I mean, in the context of statutory construction, if you haven't taken a point below, clearly the court has an interest in getting it right and not excluding issues and arguments just because they weren't raised before the CFI.
Yeah.
Thank you very much to our speakers, to our contributors. I think this now brings us on to the final quiz. As we say, anyone who gets the answers right, or the first person who gets the answers right and emails the correct answers to me or Tom, wins the prize, which is a signed copy, a first edition, no less, of the book. No doubt very valuable in the future. You are warned that Michael Black, the doyen of the DIFC bar, is on the call. The standard, the threshold will be high.
His copy.
So without more ado, I shall proceed. So question 1. In Nest Investments, the court found its necessary and proper party jurisdiction in reliance on IGC 20.7. Which jurisdictional gateway did the court use to achieve that? Which jurisdictional gateway was relied upon in the Nest Investments case by the Court of Appeal? Question 2. Which judge described the argument that the DIFC court had jurisdiction to give interim relief in aid of foreign proceedings as extreme, somewhat bootstrap, and misconceived? So a clue in the tenor of the language, perhaps, but which judge? I won't say who the advocate was that he was rebuking, but that's the rebuke.
Can I say?
Question 3: by reference to which Swiss asset management firm is that jurisdiction now commonly referred? I should say they were found to have engaged in pump and dump market manipulation. If anyone knows what that means, I'd be grateful for an explanation. Question 4. The Akhmedova case concerned the freezing of what asset? I think it was actually mentioned by Spear. And if, for a bonus point, what is the name of the relevant asset? Question 5. In which case would the conduit extended to the enforcement of foreign judgments? Harris may know the answer. And for a bonus point, at which level was that decision reached? Question 6. What happens if the JJC is deadlocked? A, both courts have jurisdiction. B, the court first seized has jurisdiction. C, the matter is referred to the Union Supreme Court. Or D, none of the above. Question 7. Who chairs the JJC? I nearly said who has the deciding vote on the JJC, but that would have been to give away the answer to a previous question. Who chairs the JJC? And for bonus point, can you name them and identify the year of their appointment? Question 8. VIH and Assas litigation established the contempt jurisdiction of the DIFC court. The case concerned a hotel on the Palm. What's the current name of that hotel? Which question? I think we're at 8 now, aren't we? Not Harris, if I'm right. 8. Okay, so 8 has a number of answers. Which DIFC court judge played rugby for Harlequin FC? Which DIFC court judge served as Director of Strategic Affairs in the Executive Office of His Highness the Ruler? Which DIFC court judge is the independent national security legislation moderator in his jurisdiction? Which DIFC court judge has been the Chief Justice of both his own jurisdiction and the DIFC? And which DIFC court judge shares a name with a leading UK Liberal politician? He may also have appeared at an earlier stage in these questions. Question 9. In Brookfield, Multiplex and DIFC, the court confirmed its ability to give anti-suit relief. The case concerned an iconic building in the DIFC from which tiles had fallen. Which building? Question 10. The DIFC court anonymizes cases using first names with the same letter. Please complete the following cases. Gavin and, Fidel B, Fidel and C, Hayri and. Question 11. In which case did Justice Field decline to recognise a decision of the Dubai Court of Cassation on the basis that it would be contrary to the public policy of the DIFC? A recent decision. Question 12. The opt-in jurisdiction of the DIFC court arose by amendment of which Dubai statute in 2012? Question 13. On which set of international principles of commercial contracts is the DIFC contract law substantially based? And lastly, question 14. Which of the following is a statutory duty of a company director under the 2018 Companies Law? A duty not to compete with the company. B, a duty not to accept gifts from third parties, and C, a duty not to disclose confidential information. So A, duty not to compete with the company, B, a duty not to accept gifts from third parties, and C, a duty not to disclose confidential information. Well, there you have it. Those are the questions. The first person who gets all the right answers to me will win a copy of the book. I look forward to seeing who that is. It remains for me to thank all of our contributors, James Wheel, Gregor Hogan, Harris Bohr, Matthew Watson, Dan McCourt-Fritz, and Sophia Hurst, and to thank all of you for attending over these 5 webinars, which Tom and I think have hugely enjoyed preparing and giving. We look forward very much, hopefully, to seeing you all again soon, safe and well, inshallah, but in any event, in person when we're able to get to Dubai. But we hope in the meantime that this series of webinars has been helpful in raising some issues, setting some debate, and having a lively discussion in recent issues in DIFC law. So without any further ado, I'll just hand over to Tom too, because Tom may wish to say something.
echo what you say, Rupert. Thank you to the team, and thank you to you as well for having the idea to do all of this, not just the book, but the webinar series as well. So I do appreciate that, and to all our contributors too. I just echo what you have to say. So I hope it is a useful book. I hope you go out and buy it, and I hope we have a second edition and we can keep it going. And it'll be, I hope, a valuable contribution to the jurisprudence. Thank you, everyone.
Thank you, everyone. Thank you very much.